Madam Speaker, while I am prepared to support the motion, I would like to place on record my concern about one of the proposed amendments. This relates to the change to Standing Order number 18 on petitions. In gist, my concern is that the new power to be given to the House must be used with great care and should never be seen to curtail the public petition process. Let me explain. The proposal by the Standing Orders Committee is to amend Standing Order 18 to provide an option for the House to decide that a petition need not be referred to the Public Petitions Committee or the PPC. This might be done if the Speaker is of the view that the subject matter of the petition relates to a matter being already before the House by way of a bill or motion, in which case the petition can be considered at the same time. The committee's report states that this is to avoid a situation where the bill or motion has already been disposed of the matter before the PPC considers the petition, making the petition moot. Under the current standing orders, all petitions initiated by the public must be brought to this House through a member who is not a signatory to the petition. In other words, the member is not necessarily a person who shares the concerns of the petitioners, but is merely a necessary conduit through which a petition may be presented to Parliament. The standing orders provide that every such petition must be referred to the PPC, except in very limited circumstances. I am concerned that this new power, if used routinely, would result in petitions not being given their due hearing or send a signal that petitions are not important. Some may ask what difference a reference to the PPC will make, since the contents of the petition can be read by members during a debate on a related bill or motion. The difference to me is very significant. The PPC is a standing select committee whose procedures are governed by Standing Order 103. The PPC is empowered to call for witnesses, papers and records, and can independently report its opinion and observations to Parliament. Compared with the procedures of the whole House, the PPC would have more time to fully investigate the grievances of the petitioners and hear them out personally if needed, and call for relevant documents, including documents from the government. The public petitions procedure is provided for by the standing orders and is a vital link between Parliament and members of the public. There is a due process that should be granted to petitioners. If the petition is not referred to the PPC, but considered by the whole House during a debate on a motion or bill, the burden would naturally shift to the member presenting the petition to fully convey the petitioner's concerns and grievances, which is probably expecting too much of the member. Madam, the recent debate on the Administration of Justice Protection Bill provides a window as to what could potentially be problematic in the future. A petition on the bill was presented through nominated MP Kok Heng Loon, but it was dealt with summarily during the debate on the bill. In that case, the wording of the bill was not made public until after it was presented in Parliament for first reading, so it could well be said that the petitioners could not have initiated their petition any earlier. In that debate, NMP Mr. Kok indicated his consent to have the petition heard together with the bill, and his view that this was appropriate should be given due weight. However, the House should be mindful that in future cases, we should endeavour to ensure that all petitions are granted their due process and hearing by the PPC. The House should bear in mind that it may be in the public interest instead to do the opposite, to defer the motion or bill unless there is urgency, until the petition has been considered by the PPC and its report sent to Parliament. Parliament might well benefit from a fuller understanding of the issue from the aggrieved or concerned persons before considering the bill or motion. In summary, Madam, while the new power under Standing Order 18 is a useful power to have, my view is that it should be used most judiciously, bearing in mind the importance of the public petitions process.
Madam Speaker, I beg to move that this Parliament resolves that the amendment set out in Appendix 1 to the report of the Standing Orders Committee be hereby made to the Standing Orders of Parliament. Madam Speaker, in March this year, Parliament directed the Standing Orders Committee to consider and make recommendations on amendments to the standing orders. The committee was asked to look at 1, amendments arising from the constitutional amendments that we passed last year, and 2, updates to the standing orders more generally. In the process, the committee considered submissions made by Mr. Louis Ng and Mr. Kok Heng Loon and accepted them where appropriate. The committee, comprising both government and opposition MPs, has completed its deliberations and unanimously agreed on a report. The report has been presented to Parliament. I thank the members of the committee for their work. I also like to thank you, Madam Speaker, for presiding over the committee's deliberations with your usual fairness and efficiency. The government agrees with the recommendations of the committee and commends them to the House. In my speech today, I will first take the House through the key recommendations made by the committee, and 2, respond to some of the issues that were raised to the committee. First, recommendations related to the elected presidency. The committee made 2 key recommendations arising from the constitutional amendments that we passed last year. The first recommendation is for Parliament to be kept informed if the President fails to exercise his custodial powers on a measure passed by Parliament within the time limits prescribed by the Constitution. Such measures include supply bills and resolutions on certain guarantees and loans. The recommendation is for the clerk to publish a notice in the Hansard and the Gazette if the President does not signify his decision on such measures within the prescribed time limit. Under the Constitution, if the President fails to make a decision within the prescribed time limit, he is deemed to have agreed with the proposed measure. The second recommendation concerns Parliament's power to overrule the President if he exercises a veto, contrary to the recommendation of the Council of Presidential Advisers. The committee has recommended that procedural machinery be put in place for this purpose. The procedures will provide that A, the President's grounds and the CPA's recommendation must be made available 2 clear days before a motion to overrule the President can be moved. B, the Speaker must be satisfied that the President's veto was in fact contrary to the CPA's recommendation as required by the Constitution. And C, there is to be a standard form of wordings or words for motions to overrule the President. The committee also made a number of recommendations relating to bill procedure. First, notice of amendments should be increased from 2 clear days to 4 clear days. A clear day is basically a full working day. The increased notice applies to both government and backbench amendments and will give members more time to consider amendments. Second, the minimum interval between the first and second reading of a bill should be increased from 7 clear days to 10 clear days. In effect, this means at least 2 weeks must pass between the first and second reading of a bill. The increased interval will avoid situations where bills come up for second reading too quickly because the House is sitting for an extended period, for example, during the budget debates. In practice, the interval between first and second readings would generally be longer. Bills introduced are generally debated only at the next month's sitting. Third, the second reading of supply bills can be taken immediately after the end of Committee of Supply proceedings, even if the usual interval between the first and second reading has not lapsed. The heads of expenditure in a supply bill would have been fully debated by the House during the COS proceedings, and it makes more sense for the House to go to the second reading immediately after COS proceedings are completed, instead of diverting to some other business or adjourning the sitting and coming back to the supply bill later. On petitions, the committee recommended that Parliament should be able to consider a petition together with a motion or bill. This will avoid a situation where a petition on a bill or motion is still being considered by the Public Petitions Committee, even though the bill or motion has already been dealt with by Parliament. The committee also made a number of miscellaneous recommendations to improve parliamentary procedure. I outlined the key recommendations. First, a member whose question has not been answered during question time should indicate within 1 hour after question time whether he wishes to postpone his question. This is to facilitate the work of the clerks, who have to circulate written answers to members who choose not to postpone their questions. Second, a member should be able to record an abstention in a voice vote. Currently, the standing orders only permit dissent to be recorded in the voice and proceedings. Third, there should be a procedure for office holders to correct any factual errors they make in a parliamentary speech. The correction will be made by a written statement circulated to members and published in the Hansard. The Speaker's leave must be sought within 72 hours after the draft Hansard is circulated. This procedure would ensure that factual errors on important policies and legislation in a speech are swiftly corrected instead of having to wait until the next available sitting to make an explanation. Fourth, the Speaker should be able to order reprints of the standing orders. The powers she would have in this regard are similar to those exercised by the Law Revision Commissioners for Statute Law. Many parts of the standing orders are drafted in very archaic styles and would benefit from some revision. Of course, a reprint cannot make substantive changes to the standing orders. Such changes would still have to be approved by Parliament. The committee also received feedback and suggestions from Mr. Louis Ng and Mr. Kok Heng Loon. I thank the two members for the suggestions, which raise important issues, and I would like to take this opportunity to explain the committee's response and add some observations of my own. It was suggested that government bills should be introduced together with ministerial statements providing key information on the bill. On this specific suggestion, the committee did not think it was necessary. If a bill is introduced with a ministerial statement, any clarifications that may be sought by members on the ministerial statement and the minister's subsequent responses may preempt the second reading debate. It is better that all the speeches and arguments be kept to the second reading debate. But I appreciate the broader point that members need information on bills. May I suggest some ways in which members can get the necessary information? Every bill comes with an explanatory statement, which will provide information on what the provisions do and the broad purposes of the bill. To some extent, the statement is technical in nature, because it has to explain the legal provisions accurately. But as far as possible, AGC will draft the statement in plain English and in an accessible way, and encourage members to read the statement for more information on the bill. For amendment bills, I would like to inform the House that the law drafters at AGC will commence on the project in July to make available tracked amendments against the main act. A soft copy of the tracked changes will be made available on the members' portal. The authoritative version of the bill will still be in today's format, but the tracked changes should make things simpler for members who wish to go into legislative detail. AGC will review the usefulness of this facility before making it a permanent arrangement. Beyond the bill itself, the general practice of ministries is to release a press statement or fact sheet, which will contain more information about the policy background to the bill. And at the end of the day, if a member needs more information on the bill that has been introduced, he or she can approach the relevant office holder before the second reading debate. I know my colleagues on the front bench will be happy to engage any member before the debate to hear their concerns. The Standing Orders Committee was also asked to consider having standing select committees to consider specific issues. Madam Speaker, the Standing Orders already provide a number of avenues for members to take the initiative in raising issues for Parliament's consideration. These avenues are accessible to government, opposition, and nominated MPs alike. So instead of looking at having new procedures and formats, I will suggest that members make full use of the existing procedures. If members need any advice on the procedures, they can approach the clerks. Finally, the committee was also asked if question time could be increased. We increased question time back in 2004 from 1 hour to 1.5 hours. At times, the 1.5 hours are sufficient to finish all the questions for oral answers. At other times, I recognize we were not able to do so. But there are only so many hours in a sitting day, and we need to strike a balance between question time and the other demands on parliamentary time. There are already instances where the House has to sit late into the night to give members time to debate bills and motions. So at this point, I do not think it is right to have a permanent increase in the length of question time stipulated in the standing orders. What the government will do is to ask the House to increase question time on an ad hoc basis if the volume of business permits. Members will recall that Parliament increased question time to 2.5 hours last July and last October on my motion. The government is prepared to continue to take this approach, having regard to the number of questions and the other demands on parliamentary time. In appropriate cases, ministers will also make statements to the House on important issues outside of question time, and members can seek clarifications on these issues. This was done, for example, during the Zika outbreak last year. I should also remind members that if a member's question is not reached by the end of question time, he can choose to postpone his question and request for an oral answer be given at the next sitting. Otherwise, the member will still receive a written answer to his question. All questions filed by members will be answered by the relevant ministries, either in oral or written form. By way of conclusion, I should like to touch on time management in the House. I asked the clerk to collate some statistics. We're now sitting longer hours for each sitting. For the 11th Parliament, we sat for an average of 5 hours, 8 minutes per sitting day. The average for the 12th Parliament was 5 hours and 40 minutes. The average for this Parliament up to April is 6 hours and 23 minutes. Last month, members recall that we sat until 10 p.m. on 4th April. These increases and the absolute numbers are not, in themselves, a matter of serious concern. We have more members now, and more complex issues facing the country. It is natural that we have been sitting longer. To some extent, we can sit longer if need be. And in fact, I would tell the House that the length of sitting is likely to continue to increase. But in overall terms, I would prefer to have a focused, meaningful sitting for a few days every month. I think this will be more beneficial for the quality of debate in the House. So I urge all members, participate vigorously in debates by all means, but keep your speeches short, sharp, and to the point. Madam Speaker, I beg to move.